Are here on In Re T, case 29658. CSB has waived, so the only person presenting today will be you on behalf of your client. We are obviously being visually and audibly recorded. I would remind you, as I know you know, not to use the name of the child. You will have 15 minutes to present your argument, and I guess we're ready to begin when you are.
Thank you. May it please the court. I'm Barbara Rogaszewski, and I represent Debbie Gaffney in this matter. Thank you. May it please the court. Juvenile court is about second chances. It's about helping families become better families. It's about helping parents become better parents by providing them the services necessary to improve themselves, and after investigation and discovery of whatever deficiencies brought the case to the court in the first place. What it is not about is to drag a family to the altar of children's services, label the parents, and then give up on them prematurely. But unfortunately, that's what happened in this case. In this case, Children's Services convinced the court that mother did not complete her case plan, though they in fact gave up on her at the 11.5-month mark, even though their case plan was filed very, very late. In fact, there were numerous instances contained in this record in which Children's Services failed the mother, and not that mother failed her child. First of all, the magistrate on May 23rd, 2018 adopted a case plan, but ordered additional requirements be added to that case plan. And the court may recall that this is a case in which the child was born in November 2017 with a very rare genetic disorder called Lowe's syndrome. It's a syndrome that runs in this particular family, and it causes kidney disease, it affects the eyes, it affects the cognitive abilities of the child, and it causes severe delays. The child spent a good bit of time in the NICU. He was born prematurely and underweight, and when he was released from the hospital, he was actually released to the custody of Children's Services. So it wasn't a matter of mother not providing proper care for him, because he was really never in her care in the first place. This was a matter of a mother who had lost children previously, so Children's Services took this child from the very beginning. And then, yes.
Was there any, I know the child was in the hospital for, it looks like 8 to 10 weeks prior to being released. Is there anything in the record about mom's involvement with the child while he was in the hospital during that time?
I believe that she was visiting him, and she was also working with Children's Services. They actually filed 2 cases.
Right.
So although the case that we're here on now was filed in March 2018, Children's Services, upon the child's release from the hospital, immediately filed for emergency custody. So, but I believe she was actually involved with visiting the child while he was still in the NICU.
And to the best of your knowledge, that information is in the record.
I believe it is. So when the child was released from the hospital, he was directly placed into foster care. And mother then had the burden, of course, of proving she had the ability to care for him and his special needs. And the problem is that I believe the case, they ran out of time. So they dismissed March 1st, 2018, and then refiled the case. So the first case plan that was presented to the court was adopted May 23rd, 2018. However, the magistrate specifically ordered additional case plan objectives to be added to that case plan objectives for mother, specifically designed to have her educated about Lowe's syndrome, have her involved in the child's medical care, also to investigate her cognitive delays and her mental health, and for Children's Services to investigate on behalf of mother and the child certain services that would be available to the family, whether it was transportation, yes,
And were those additional requirements outlined at that hearing, or were they added afterwards once the magistrate wrote up the dedication and put it out? Did mom know at the time of the hearing that there were additional requirements that were going to need to be?
I don't know if they were specifically stated in the hearing, because I don't have a transcript of, I believe it was at disposition. And I don't have a transcript of the disposition. I do know that the dispositional order specifically outlined what case plan objectives would have to be added to the case plan.
Okay, thank you.
And then, of course, the agency was also ordered to add to that case plan investigating services for the family, whether it be transportation services, whether it be in-home services for the care of the child, perhaps like an in-home care company or something like that. And then, of course, direct financial assistance to the family as a result of the child's disability. So those were aspects of a case plan that was supposed to be expanded for the benefit of the family. Well, then the magistrate reiterated in another hearing, I believe it was in June of 2018, to again expand the case plan and add those case plan objectives. It wasn't until October 2018 until the agency added any of those case plan objectives to the case plan. So that first amendment wasn't done for 4.5 months into the case. Actually, more than 4.5 months, about 6 months into the case after it was first filed, but 4.5 months after it was ordered. So the agency actually wasted a full third of the case not adding or complying with the additional case plan requirements that the court specifically ordered to be added. Problem one. Problem two. Then, once those case plan objectives were added to the case plan in October, Children's Services then completely ignored some of them entirely. And they actually never were discussed again, never addressed. There were no services provided, no investigation. I don't even think any discussion of it was contained in the trial transcript from the permanent custody hearing. Specifically, they completely ignored the requirement that Children's Services, again, investigate agencies to assist mother in caring for the child, whether by transportation, financial subsidy, or direct care. And again, for a parent, a single parent with very little family support, who herself might have cognitive delays and mental health issues, what difference could those services have made, at least knowing they existed and putting the pieces in place to have that available to the family as she's working through her part of the case plan? We know that in our court here, this court addressed this issue in the case of In Re HS, which I've cited in my brief. In that case, the court found that you cannot sever parental rights when Children's Services violates a court-ordered case plan, doesn't provide the services as required in the case plan that the court themselves ordered. In the case of In Re HS, as we may recall, we had 2 parents and 4 children, and the parents had cognitive delays. They also had mental health issues that were pervasive throughout the course of the case. They both went to Summit Psychological and had parenting and mental health evaluations. And the court then subsequently ordered Children's Services to provide in-home parenting education that included the children, and that was specifically tailored to meet the cognitive abilities of the parents. Well, that case went to permanent custody 3 times. And it went to the Court of Appeals twice, and it was overturned twice, because Children's Services twice did not provide the in-home parenting education hands-on with the children that both this court and the trial court had ordered them to provide. And this court repeatedly said, when Children's Services did not provide the case planning and the services that are necessary to reunify the family, we are not going to terminate parental rights. So that was problem 2 in this case, that Children's Services completely ignored one of its own case plan objectives as ordered by the court. Then we have a third problem. Mother had a case plan objective to undergo a mental health and parenting evaluation. That was again ordered by the case plan amendment in October of 2018. Mother actually completed her evaluation through Summit Psychological in December of 2018. She complied with that. Well, what good is an evaluation and recommendations? And those recommendations were provided on January 9th of 2019 in that report, but not made available for now, about another week. What good is a parenting evaluation and recommendations if Children's Services doesn't take any action on it? Once that report and recommendations was made available, Children's Services did nothing with it. They did not amend the case plan to include any of the recommendations. They did not, as far as we can tell, make any referrals that would assist Mother in complying with any of those recommendations that she needed to do. Specifically, Mr. Stranathan, when he wrote his report, made a recommendation that Mother should be evaluated for medication to address her depression. I believe she had chronic depression and anxiety. But after that report is released, we don't have anything in the record to indicate that Mother was sent to an agency, any kind of mental health agency, to be evaluated for medication management, or whether that would even be necessary. The report also—
Question then. Were those results of the parenting evaluation, mental health evaluation, those available to Mother? Did she know what the recommendations were before she even went into court?
That I don't know. And I don't know that that's contained anywhere in a particular record. I do know that based upon my experience, not necessarily with this case, that the evaluation report is not given to the client, which would be Mother. I do know that Mr. Stranathan actually testified in a subsequent hearing after his report was released. And I believe that the court indicates in their in the magistrate's order that he testified extensively about his evaluation process, her diagnoses, and his recommendations. So she would have heard it in court at the very least.
Thank you.
Thank you, Your Honor. So one of the recommendations that Mr. Stranathan made was to have her evaluated for medication management. There's nothing to indicate that that happened, that she was given a referral for that. And then the other recommendation that is stark is that Mother obtain a parenting education specifically modified for her cognitive ability. We don't have any indication that that was done credibly. There was some conflicting testimony in the record by the caseworker. First, she testified that there was no referral made for that. And then she later testified that she may have made a referral sometime in February of 2019. However, the agency filed for permanent custody in February 2019. So even if they had made the referral, it would have been right before they filed for permanent custody. So Mother would have had no way to comply with any of these recommendations by Mr. Stranathan, even if any of that had been put into place. But there's no indication that it did. The only recommendation that the agency did follow was to take Mother's visits from monitored in her home. They moved them to the Family Interaction Center, and then they changed them to closely supervised. Even though there was nothing to indicate in the record that she was a danger to the child or she wasn't providing them proper care. So and then they just gave up on her at that point. They filed a motion for permanent custody, said she'd failed to remedy the conditions that brought the child into care, and that she hadn't complied with her case plan requirements and hadn't completed it.
Counsel, just so you know, you have about a minute and a half left.
Thank you.
Mm-hmm.
So again, in Ray HS, it's the exact same scenario. Children's Services didn't take the action required on their own case plan to help the parent become a better parent. Instead, they used the case plan and the recommendations by Summit Psychological Services as an excuse to give up on Mother a mere 1 month after the recommendations were released. This court has already found that if Children's Services doesn't provide proper case planning and follow through and give the parents all of the services that are required by court order, then we cannot terminate their parental rights. The child has a constitutional right to be raised by a parent, and the parent has a constitutional right to raise their child. And we have to afford both of them every procedural safeguard before we terminate parental rights. And that's what this court has done in Re HS. That's what this court must do in this case. Thank you.
All right. Thank you very much for your argument. We will take the matter under advisement, issue our written decision in due course. It will be mailed to you as well as the opposing counsel, as well as posted on our website and that of the Supreme Court. You have a good day.